Good morning and welcome to this Corney & Lind webinar. My name is Joe Swin. I'm with the business development team here at Corney & Lind. And before we get into the main presentation today, I'm just going to go through some quick housekeeping. If you've got any questions about the webinar, do enter them in the chat box on the bottom left hand side of your screen. A copy of this recording is going to be made available after the presentation. So if you check back on our website in a couple of days, you'll be able to see that. Today's webinar is entitled Uniform Policy and Other Policies, Inclusion and Discrimination. And it's being presented by Michaela Vaughn, who's a lawyer here at Corney & Lind, and James Tan, one of our senior associates. So I'm just going to give a quick introduction to each of our presenters. So Michaela completed a Bachelor of International Studies and a Bachelor of Laws and Legal Practice from Flinders University in South Australia, and is currently pursuing a Masters of International Law at the University of Sydney part-time. Michaela works, amongst other areas, in our commercial team, so has an array of experience in policy and other areas related to today's webinar. And James was admitted as a solicitor of the Supreme Court of Queensland and the High Court of Australia in 2013, following extensive legal training in our office. He's got an array of experience as well, notably in commercial litigation and commercial front-end work. So two great presenters, and I'm going to hand over to Michaela now.
Thank you, Joe. As Joe said, the title of today's webinar is Uniform Policy and Other Policies, Inclusion and Discrimination. Obviously, discrimination and the issues that surround potential discrimination claims are something that schools are increasingly aware of and increasingly concerned about, because there are many complex issues that need to be taken into account. So today's webinar is designed just to give you a little bit of an overview about the area, some introduction into some basic concepts, and hopefully send you away with a better understanding of the law around it, and enough so that you're able to know when something is a potential issue and seek proper advice. So let's move on. So the big question, what is discrimination? I'm sure that's essentially why many of you are here. So what is discrimination? The first thing to note about discrimination law is that there's no one answer about what discrimination is, because it is very jurisdictional. So depending on what state you are working in will change the law that is applicable. Some of the acts in this area are being put up on your screen right now, and you can see there are many of them. Some are Commonwealth, some are state, and that's not to mention the international legal implications of discrimination law. So it's a very complex area of law jurisdictionally, so any issue that arises needs to have specific advice to your context, because the state that you work in will have a different law to another state, which may be different to the Commonwealth law. So make sure that you get individualised advice if you have concerns about a potential discrimination issue. But the general idea around discrimination is that the person who is being discriminated against has a protected trait or attribute. This list is some of the protected traits or attributes under the legislation. So you have sex or gender, sexual orientation, race, religion, disability, age, marital status, pregnancy, political association, etc. Now, the idea is that if someone has one of these protected traits or attributes, discriminating against them is against the legislation. So what I'm going to do is introduce you to something called the comparator test. Now, this test is used to kind of get an idea of whether discrimination has occurred, and essentially the idea is that if someone has one of these protected traits or attributes, you compare your conduct towards them to your conduct towards someone else of that who does not have that trait or attribute. So if you're hiring someone and they are pregnant or Muslim or Asian or male or female or gay, bi, whatever it is, over 50 years old, under 50 years old, Labour, Liberal, your treatment towards them must be the same, regardless of whether they have one of these traits or attributes. And you need to be able to show that you're treating people from these diverse backgrounds in the same way. There are two ways that you can discriminate against someone generally under the legislation. There's direct and indirect discrimination. So direct discrimination is where one treats or proposes to treat a person with an attribute less favourably than they would treat someone who does not have that attribute. So let's say that let's use disability discrimination here and say that someone's seeking enrolment to your school and the student is disabled. Direct discrimination would be where you say, I'm sorry, we don't accept disabled children at our school. Obviously, there are issues with that. But it becomes a little more complicated when you look at indirect discrimination, which is where a condition is placed on access to a good or service that someone with that trait is unable to meet. So using the same example, a child with a disability is seeking admission to your school, and your school has a policy whereby your students must be able to, let's go way off, way out here and say all your students must be able to play soccer, okay? And that's a condition of entry to your school. And someone in a wheelchair is obviously unable to play field soccer, and you say, well, you can't be enrolled at our school because being able to play field soccer is a condition of entry to our school, so I'm sorry. That's an instance of indirect discrimination. You haven't said, you're in a wheelchair, you cannot come to our school. You've said, you cannot play field soccer, you cannot come to our school. So hopefully that example gives you a bit of an idea about the difference between these two methods of discrimination, but it's important to bear in mind that they're both discrimination and both are against the legislation. So whenever you're looking at this, you always need to think about the comparator. So always, when you're looking at your conduct and the conduct of your staff and your policies, always look at, or always compare your conduct towards the person with a trait or attribute with your conduct towards someone who does not have it. And that's something that you can keep in mind when you're addressing these issues. So obviously you're sitting here going, well, this is kind of ridiculous, like there are millions of instances where discrimination can happen. What about same-sex schools? Same-sex schools are an example of huge amounts of discrimination. They explicitly say directly, if you're male or female, you cannot attend our school. How is that okay? Well, the legislation makes exemptions for this, okay? So all jurisdictions have an exemption for same-sex schools, allowing them to discriminate on the basis of gender. So if you are if your workplace is a same-sex school, you don't need to worry about a million claims coming at you right now because there is that exemption. Other defences and exemptions include the religious exemption. Now, this exemption is structured differently depending on which jurisdiction that you're in, but the basic concept is that if you're a religious body and the discrimination is around a practice that conforms to the doctrine of your religion or is necessary to avoid injuring the religious susceptibility of your adherents, then there's a potential exemption for discrimination. So if, for example, so this is how the Catholic Church, for example, is able to get around not employing women in ministry. Because that's part of their doctrine, of their religion, that's necessary to maintain, and its adherents are okay with that, and it's part of their official religion. So not employing a female in Catholic ministry is okay under this exemption. When it comes to unjustifiable hardship, except this is another exemption. So this goes towards primarily physical disabilities or disabilities in discrimination, and essentially there's a requirement for schools, and we'll go into this in a bit more detail later, but there's a requirement for schools and bodies to make reasonable adjustments for students with disabilities and staff with disabilities, except where such adjustments would cause an unjustifiable hardship. Now, this test in the school context has been has primarily been found to exist with what would probably be termed classroom dynamics more than adjustments for physical disabilities. Okay, and we'll go into the case law around that a bit later. But it's important to have in mind that the unjustifiable hardship exemption is available. Now, sport is another exemption. So obviously male and female sports are okay. They're a thing. You don't have to have women in men's team and men in women's team. In some jurisdictions, though, under 12 years old, discrimination in the sport area is possible. So if you have a question about that, seek legal advice because it differs between jurisdictions. But in general, sporting teams can be sex segregated, and there are exemptions in relation to that. Another is a genuine occupational requirement. So if, for example, you're a religious body, and this is in addition to the religious exemption, but if you're a religious body and your work is entirely based around your religious faith, and then you could argue, for example, that hiring someone of another faith is not okay because it's a genuine occupational requirement that all your employees adhere to your faith. Another example would be if you are, for example, a bricklaying company and you're hiring bricklayers and someone with a physical disability comes in and wants to be hired, and you say, well, can you do the work? And they say, well, no, because of my disability. And they're like, well, that's a genuine occupational requirement. You have to be able to do this work. In that instance, there is a defence available. So it's not a clear-cut area of law. This is very much an area of law that is based on the facts of the case. So if you have a question, it really turns on the circumstances around the case. Now, the primary title of today's webinar obviously focuses around uniforms, so let's spend a bit of time around that. How can uniforms be an instance of discrimination? Firstly, it's clearly an issue where indirect discrimination can come into play because you're not saying, direct as well, but the case law here focuses primarily around indirect because the case law focuses around things to do with religion and adhering to religious for want of a better term, religious headwear and religious items of clothing, and how that impacts on uniform policy. And one of the questions that needs to be asked is, are the requirements that you're placing on your students reasonable? And another question that's been explored in the case law is, can the religious exemption apply? Another note, just quickly, is about transgender persons, because this is obviously an issue for uniform policy as well and discrimination in this area. So if you have a student who's transgender, are they going to wear a dress uniform, female uniform, or are they going to wear a male uniform? And there's a whole ton of issues that comes with this. So get specific legal advice. I know I keep saying that, but I can't emphasize it highly enough, because this is a difficult situation for schools to manage. But some things to think about, and firstly, we would recommend having a sit down with the family and the student if this is an issue in your school, discussing these kinds of issues. But you need to be thinking about things like uniform. Come to an agreement with the parent and the student about the gender they're going to identify with, and the uniform requirements according to that gender. Maybe consider getting a gender neutral option for them. But talk that through. Talk about toileting and change facilities. Are they going to use the men's or the women's change room? Maybe there's a disabled change room and toilet they can use. Camps, behaviour, class segregation. That's not so much an issue now in most schools, but that can come into issue. Do you have, for example, in sexual education, do you separate your students based, when you're discussing those issues? And remember that it's not a single point in time situation that you're looking at, it's a transition. So you need to be looking at that whole process. If you have a student who's undergoing transition, look at where they are before transition, where they are after transition, how you're going to support them throughout that. Look at each stage in that process and address it accordingly, and go from there. But have these conversations as soon as you're aware that this is something that's coming up, because otherwise all these issues can actually become quite a big issue for the school. Now, let's look at some of the case law. Again, this is one of the most recent cases, Aurora and Melton Christian College. This comes out of the Victorian jurisdiction, and a Sikh family sought to enrol their son at a Christian college. So there are obviously already some kind of questions going off in your mind. How can a Christian college accept a Sikh student, etc., etc.? Well, this is how it panned out. They were told that it was a condition of enrolment that the student comply with their uniform policy. The student and his family insisted that he wear what's called a kesh, which is a particular head covering and, uncut hair, as well as a head covering that are specific to adherents of the Sikh religion. This was contrary to the uniform policy. And they refused to abide by the uniform policy. They refused to make the student cut his hair and not wear the headdress. And the school therefore refused the enrolment. Now, there are some issues here specific to the context of the school, but it was found to be indirect discrimination. They didn't say, oh, we don't accept Sikh students. They said, oh, we don't accept students who don't abide with the uniform policy. And the court found that, the tribunal found that the college had not made reasonable adjustments. The school had not sought to make the adjustments necessary to include the Sikh within a reasonable framework. They could have easily said, well, yes, that's fine. I mean, who's going to be hurt by a student wearing a particular head covering or wearing uncut hair? Now, is the religious exemption applicable here? Because obviously this is a Christian college, this is a Sikh student. Would wearing the head covering of a different religion offend the sensibilities of the people and students in the school community? The tribunal said no. And they said no on the basis that the school already had quite a diverse student body. So it's not as though all the students and all the staff and all the families involved were Christian. That actually wasn't the case. In fact, the tribunal said you have a very diverse makeup of students. This failing to make reasonable adjustments for this student on the basis of his Sikh religion is discrimination. So the interesting thing is that 25 years before this case, a similar case was heard in the English House of Lords. So this is obviously in England, but this is a kind of a case study that is not new, and it's an issue that schools have been contending with for a while. So a Sikh boy was refused entry to Park Grove School, Birmingham, by the headmaster because his father refused to make him stop wearing the dastar and his kesh. So already you're seeing similarities. The boy went to another school, but the father lodged a complaint with the English Commission for Racial Equality, and the English House of Lords found that this was actually based on racial discrimination because the Sikh religion is racially based. And it was found that the conduct of the school was discrimination. So again, this is not a new issue, and it's probably not going away anytime soon. I'm sure you can start thinking about a million different kinds of instances where similar situations might arise in your school. So it's important to be aware of this case law. Moving on from religion and from uniform, what about disabilities? Okay. So again, we've talked about the reasonable adjustments and the unjustifiable hardship exemption. So schools need to make reasonable adjustments to accommodate students with disabilities. Okay, that's a legal requirement. But you're not required to make adjustments that would cause the school unjustifiable hardship. So what has the case law said is a reasonable adjustment, and what is unjustifiable hardship? Again, as I touched on earlier, the case law tends to focus more on classroom dynamics and the stress on the teaching environment rather than on financial stress. So for example, in Purvis in New South Wales, a student repeatedly assaulted teachers and other students as a result of the brain damage suffered in the student's infancy. The evidence before the court was actually that a lot of this conduct was almost constituted criminal conduct. This student was quite violent, and there were significant issues, and the staff just didn't know what to do. The school excluded the student and suspended the student on the basis of this conduct. Initially, the commissioner found that suspending the student and expelling the student constituted discrimination on the basis of the disability because this conduct arose from the brain damage that the student had suffered as a child. However, this was dismissed on appeal because of the comparator test. So the court said, well, the commission actually erred in finding that this was discrimination because it's not the disability that's the issue, it's the conduct. And any other student who committed conduct of this wouldn't have been given anywhere near the leeway that this student had been given. Any other student would be treated exactly the same way. And so the court said, well, this isn't discrimination. This is genuine protecting of the teaching environment. You're not treating the student any differently to how you would treat any other student. It's not discrimination. Conversely, in Hills Grammar School and Human Rights versus the Human Rights and Equal Opportunity Commission, Hills Grammar School in Sydney, which is a private school with a particularly hilly and natural setting, had a request for enrolment from a young student with spina bifida. She required wheelchair access, and the school, being a very hilly and spread out school, costed the relevant modifications and refused the enrolment on that basis. They said, look, this is just going to be too expensive to make these modifications to our school. They estimated it to be $1.1 million. The court found not only that the adjustments would be significantly less than that, they found that paying this money and making these modifications was not an unjustifiable hardship on the school. The court found that this was, in fact, discrimination. So that obviously was not the outcome that Hills Grammar School wanted, but that was what the court found, and that's the case law that we're working with. So in general, the case law shows that where the teaching environment and the staffing requirements and the risk to the student body in terms of classroom dynamics is at risk, it's more likely that an unjustifiable hardship will be found. On the other hand, expending money to make certain modifications, perhaps having an extra teaching aid if you have someone with learning difficulties, etc., that sort of thing will not generally entitle you to argue the unjustifiable hardship exemption. So it's important to be aware of that. Having run you through this, how do you avoid a claim? I'm sure that's the question that you came with hoping to get an answer to today. Well, again, keep the comparator test in mind. Have that in the back of your mind when you're dealing with potential discrimination issues in employment and enrolment and uniform policies, etc. Know that indirect discrimination is against the legislation too, so it's not enough to say, I didn't say you're black, I don't want you. I said that, X, Y, Z. Indirect discrimination is just as against the legislation as direct discrimination is, okay? Putting a requirement upon admission to a good or service that someone with a trait cannot meet is against the legislation, regardless of whether you explicitly state that it's because of that trait. Regardless of whether you explicitly state that it's because of that trait. And again, can't emphasize highly enough, if you have any questions, if you have an issue that you need resolved, get legal advice specific to your circumstances, because this is an area of law, again, that is very, very driven by the facts of the case. So hopefully this webinar has been useful. We have some time now to answer some questions. Is there anything that you wanted to add first, James?
I think the Melton Christian College case is a very interesting one, because I think a lot of religious schools today are dealing with that issue, and particularly with having to open up the enrollment policy and have a very broad enrollment policy. And I think that was particularly where the school ran into some difficulties. The decision of the tribunal spent some time focusing about how the school, which holds itself out as a Christian school, does not, in fact, have an enrollment of purely Christian students. It has a very diverse and open enrollment policy. So at that point, it seems as though it becomes more difficult to rely upon the religious exemption. The other important point of note from that decision as well is the way they enforced the policy. It was a very strict enforcement of the policy, and I think from my reading of the decision, it's one thing to have a policy in place, and that in itself may not necessarily be discriminatory. But the way it was enforced without allowing for exceptions or an exception to the policy seemed to have put the school in a bit of strife. The tribunal member who decided the decision drew a very interesting comparison where the tribunal member said that it would be unreasonable for the school to require someone to look of a certain faith. Particularly when you have the open enrollment policy, and also on the context of exemptions, the school would have made adjustments to the enrollment policy if the attribute which was discriminating was, for example, a child had broken their arm and was and had to be put in an arm cast. perhaps the or a leg cast, which would be from a strict interpretation of the uniform policy, a breach, because they wouldn't be dressed in accordance with that. But because of that disability, an exemption would be made. So drawing that comparison between the two types of attributes of discrimination, the tribunal was quite scathing of the way the college had enforced the uniform policy. So I think the take-home point generally from this topic would be a lot of uniform policies, particularly for religious schools, may have been incorporated with a very strict method of enforcement. But the way the law is moving in Australia at the moment, it may be a time for those policies to be reviewed, and particularly the procedures to be reviewed. Michaela brought up a very good point of having a conversation with having a very careful conversation with the potential enrolling parties. It's a decision that should be made slowly, because if it's rushed, if a rash decision is made without properly considering the implications of not granting an exemption, potential liability could arise. But we also have to consider the flip side, that if a policy is not adhered to, what does that send out in terms of the is that effectively achieving the vision and mission of the college? And so it's a bit of a balancing act, but we have to be very carefully aware of where the law is moving at the moment and what is reasonable and unreasonable, particularly in today's legal context. I'll hand it over to questions.
Just a quick note, if you've only just joined us, the recording of this webinar will be made available. If you check back on our website in the middle towards the end of next week, we'll have a copy of this webinar and a copy of the slides available on our website, because there are a lot of bits and pieces involved in this. So yeah, it's always good to be able to come back and review that. And we just wanted to extend an offer. If your school is looking to get a tailored continuous professional development presentation to the needs of your school, we've got an offer for schools in which is the price is $2,500, and for that you get a 2-hour seminar at your school for as many staff as you want included in that. Some take-home packs to come with that and more resources. Now, this would be tailored to the issues that your school wants to deal with. So whether it's discrimination, whether it's child protection, there are a number of different areas that we can help with. So if that's something that that sounds interesting, please do feel free to get in touch with our team. But as I mentioned, the copy of the recording will be made available during the middle to late next week. So check back on our website for that. And yes, the next webinar will be on the 23rd of March, and it's going to be covering dealing with high conflict parents. So if you know somebody who might be interested, please do share the link with them, which is at corneyandlind.com.au, and you can find it in our resource centre. So yeah, that sort of wraps it up for the webinar today. But thank you so much for taking the time out of your day to join us. If you've got any further questions, please do feel free to get in touch and speak to one of our business development team. We'd love to help. But yeah, thank you so much, and yeah, enjoy the rest of your Friday and have a great weekend.